finishing up the buyer section, and then we are moving on to some other sections. I did not record any lectures for this week intentionally, and that's because, like I said, I'm working with a new text, and I originally, when I set the reading for this year, thought that I would do more with the stuff that I assigned for today. And reading it again, I've decided I've never tested on this stuff in the past, and I'm not going to start this year. So I will go over it. We'll go over it quickly, in part because there is a chance, very small chance, that some of it might be tested on the bar, and I want you to know of the language. But I'm not testing it, so I don't want you to review it for purposes of my exam. Okay, so that's why I don't have any recorded lectures on it. So we're gonna go over it, and you'll have the information. But I'm not going to do anything with it myself. The other thing is, I posted a problem from a past bar exam for last week's reading on buyers. We'll maybe spend a minute or two looking at it, but I'm thinking now as we're getting towards the end of the semester, and you want to start thinking about how to prepare for the exam. This is actually a great question for all of us to work through together. So what I'm going to do, that if you recall in the syllabus I had in there that I would ask you guys to write out a problem for the end of the semester. What I'm going to do is ask you to write it out over the course of this next week, hand it in to me. I'll set up a thing on Blackboard where you can submit it online, and then we'll go over it together in class. So what I want you to do is write out your answer to it. Doesn't have to be 15 pages. I think if you do like half a page or a page, just sort of work through the issues, that'll be fine. So what I'm asking for is a good faith effort on your part in trying to answer the question. And then at the beginning of class next week, we'll work through it together and see how we would approach it as an essay question. Because this is a real bar exam essay question. I want you to take the time to work through how to answer it, and then we'll work through it together in class. So I'm not going to separately grade it. We'll work through it together. Does that make sense? Everybody good? That way. And then I will also post past exams of mine, so you will see how I ask questions, but they're much in the same vein as this exam question, which is from bar exam. Okay? This question that I've posted in the material will count as the assignment that you were expected to do this semester. And all I'm asking for, again, is good faith effort, and hand that in to me, and we'll work through it together in class. Okay?
So bring a hard copy, right?
Yeah,
Okay.
yeah, whatever, so you can take notes.
Yes.
Yeah, okay. You'll submit it online.
Oh, okay.
Yeah, I'll just create an assignment. You'll get credit for submitting it if you put in a good faith effort into answering the questions. You don't have to get it right to get points. I just want you to work through it. Okay, so we're starting with buyers. Before we get going, I want to make sure there are no questions left over from last week. Again, I show us as having finished to the point where we were about to start question 87 on 217. Everybody good with that? That sound right?
That's right.
So if you recall, we're starting off with a general rule with buyers, which is 9315A1. The security interest continues in the collateral, notwithstanding a disposition or a sale of that collateral. That's the default rule or the starting point. But it doesn't always continue. That's just the first step. It continues unless. We've talked a little bit about the buyer in the ordinary course of sale. And I just want to take 2 minutes to talk about that. Just remember, I think where people get caught up in the buyer in the ordinary course is they think it's the buyer in the ordinary course of the buyer's business. That's not the rule. The test is buyer in the ordinary course of the seller's business. Okay? So, if you're Walmart, you sell TVs. But if you're Walmart, you don't sell trucks. Okay? You have trucks, and maybe you sell them, but you're not in the business of selling them. And so when someone goes to Walmart to buy a TV, they are a buyer in the ordinary course. But if they buy a truck from Walmart, they are not a buyer in the ordinary course. questions about that before we start with 87? No? Good. All right. Well, I'm glad it's making sense. So let's talk about problem 87. We have Andy Audio bought a stereo receiver on credit from Voice of Japan, and he gave a purchase money security interest in the receiver. Voice of Japan did not file a financing statement 6 months later when Andy still owed Voice of Japan's $300. He held a garage sale and sold the receiver to Nancy Neighbor for $200 in cash. If Andy stops making payments to the Voice of Japan, can it repossess the receiver from Nancy? So let's just chart out what happened to this receiver. So who's the original buyer? Andy Audio, right? And Andy Audio granted a security interest to Voice of Japan, right? And then Andy sells it to Nancy. So that's a security interest is granted to them, and a sale of the receiver to Nancy. Who does Voice of Japan want to foreclose on? They want to get the property back from her. Is she a buyer in the ordinary course? Is she a buyer in the ordinary course? Well, who sold the stereo?
Andy Audio.
No, Voice of Japan sold it to Andy. Who sold it to Nancy?
Andy.
Is Andy in the business of selling stereo equipment?
It was a garage
Is-
sale.
Nancy a buyer in the ordinary course? No. Andy was, but Nancy isn't. 9315A1, does the security interest of the Voice of Japan continue in the sale? Yes, unless. So what's the unless in this problem? It's not buyer in the ordinary course.
Correct.
The garage sale exception. How does the garage sale exception work?
How it sounds. No, I'm just
No, it's exactly, it's called, it's the nickname, and in this problem, we set it up as a garage sale. But it doesn't have to be a garage sale. Why is it a garage sale? So it's stereo equipment, right? Voice of Japan did not file a financing statement in the audio equipment, right? Stereo. Why did Voice of Japan not file?
Automatic.
And it's automatic perfection. Why is it automatic perfection?
consumer
It
goods.
was PMSI, Voice of Japan, Consumer Goods.
So this sale here was a purchase money security interest in what else? What was the equipment to Andy? Does that matter? Does it matter that they're consumer goods?
Mm-hmm.
Yes, because the only kind of automatic perfection that we get with respect to this collateral here is because it's consumer goods. Right? If it's any other product, the purchase money security interests that we see require a filing of a financing statement within 20 days, right? But that's not what this is. This is consumer goods. So can Voice of Japan just rely on the existence of the security interest as its method of perfection? Yes. So there's no filed financing statement. The equipment in Andy's hands are consumer goods. What is the equipment in, and I say equipment, stereo equipment. It's not equipment for Article 9 purposes. That's probably a bad term, right? What do they call it? A receiver? Is that what it is? Let me change that. I hate using words that have definitions. That was a mistake. So it's a receiver, right? To Andy, it's a consumer good. What is it to Nancy?
Consumer
And how do we know it's going to be consumer goods to her?
garage sale.
Well, can a business buy stuff at a garage sale? If you own an antique store and you go around to garage sales and you buy goods for your store, are you buying consumer goods? Are they consumer goods to you?
No.
No. What are they to you?
Inventory.
Inventory. Does the garage sale exception apply to inventory?
No.
So it has to start out as a consumer goods, and it has to remain consumer goods in the hands of the buyer, right? If Andy was in the business of selling audio, keep using the word equipment, right? Receivers, this would have been equipment, right? How would Voice of Japan had to have perfected? File the financing statement, right? Okay, so there's only automatic perfection because it's consumer goods in Andy's hands. All right, Nancy buys it. How do we know she's using it as consumer goods? I dare somebody to say it loudly and not mumble. Oh, now nobody's going to talk. Okay.
Because her name's Nancy Neighbor and Nancy Business.
The garage sale exception won't apply to her if she's buying for her store, right? Then it's inventory. Or if she's going to use it at her place of business, then it's equipment, right? It has to be consumer goods in her hands. In order for it to be consumer goods, what do we have? How does the debtor have to use it? Personal, family, or household purposes, right? She can install it in her house for use by her family. That's cool, right? Then it's consumer goods. Okay, and what else do we need in order for the garage sale exception to apply?
BFPV,
Sorry?
or what is it, BFPV?
Bonafide purchaser
Yeah,
for value.
bonafide purchaser for value.
Without knowledge of what?
Just security interest, yeah.
She can't know. So remember, for the buyer in the ordinary course, it's okay if you know there's a security interest. To use the garage sale exception, can you know the existence of the security interest? No, you have to be unaware. You have to be a bona fide purchaser for value. What section of the statute are we looking at?
320B.
Okay. So just follow the statute, right? 320B. A buyer of consumer goods from a consumer seller where there is no file financing statement and the buyer does not have knowledge of the existence of the security interest, the buyer in that sale takes free of the security interest created by the seller. Okay? 9320B. And the reason it's called the garage sale exception is you can imagine that's where many times consumer goods are sold. So if you just think of it, it doesn't have to be a garage sale. That's just the nickname. But it's a sale by a consumer of her consumer goods to someone who is going to use it as a consumer. There is no filed financing statement, and the buyer is unaware of the existence of the security interest. Okay, so you're a secured party who sells consumer goods, and you're worried about this exception. What do? File a financing statement. Easy. You do that. Does your security interest continue? Okay. First thing. The second thing is you could make the buyer aware of your security interest. How might you do that? Put a sticker on it, right? This product subject to a security interest by Voice of Japan. I'm not sure that works as well, but if somebody goes to buy it and it has a sticker on the side and it says subject to a security interest, it's very hard to argue you don't have notice of the existence of the security interest. I like the file financing statement better. So you're advising a client that sells consumer goods, but they're of high value. What's your advice? File. Yeah. And then the buyer does not take free of the security interest. Yes.
So, do the courts practically believe people will, does the garage sale exception still apply? Like, who's gonna check the filing system when you're at a garage sale for any items?
No one.
Right.
That doesn't mean stuff doesn't get foreclosed on.
I'm just saying, it seems like all the policies geared towards protecting buyers in good faith for value.
Yeah.
But if they file, what's being filed, it's the buyer's not protected.
Correct. Who wrote the statute? The banks. When in doubt, assume the bank wins. Buyers, we like buyers, okay? So buyers have preferred status in the system. What we wanted to create, what the drafters wanted to create was a situation where the typical sale of a consumer good subject to a security interest, there's no file financing statement. 99.9% of these sales of the kinds of products we're talking about, there's no financing statement. It is rare. Now, where would we likely see it? Well, you sell consumer tractors. You'd probably file a financing statement, assuming there's no title. Yeah. So we wanted to create a circumstance where the bank could protect themselves for high value items, but for typical consumer goods, they didn't, because it's expensive to file, right? It's not a costless system to file a financing statement. So they don't have to file, but they are subject to the garage sale. And mostly, how much, you buy a piece of, I keep wanting to say stereo equipment, right? This is me from the 70s, right? This cool Yamaha, Onkyo receiver, man. That thing was great. Huge, weighed 50 pounds. And I had speakers that were enormous. But I had the best damn dorm room in college. Turntable, the whole bit, all right? How much is that stuff worth once it's been in a kid's college dorm room for 4 years? How much would you pay for a used piece of stereo equipment? Not a whole lot. So mostly these sales, nobody cares. They're probably writing the store is probably writing this off. Okay, good. We feel good about that one? So don't confuse the garage sale exception from the buyer in the ordinary course. A consumer buyer from a consumer seller is never a buyer in the ordinary course because consumers are not in the business of anything. Right? They're just consumers. If they're selling stuff that they purchased for their business, they're not a consumer seller. And that's important to keep in mind. Great. How about problem 88? Notes here. We have somebody operating an ice cream truck, and then they go and sell the ice cream making machine. Okay, so our RFC has a perfected filed security interest in the equipment of White Truck Ice Cream, and then White Truck sells one of the components of a truck, an ice cream making machine. Does he lose? It says here, when Frank refused to turn over the ice cream because Bill's White Truck sold to Frank, does Frank take free of the existing security interest?
So since they're not in the business of selling ice cream machines.
Right, they're in the business of selling ice cream.
Right, so this would be a consumer good.
Well, is it? What is it to the
Oh.
White Truck Company?
To them, it's equipment.
It's equipment, so 9320B doesn't apply.
Okay.
Is it are they in the business of selling ice cream equipment, ice cream making equipment?
No.
Okay, so it's not buyer in the ordinary course.
So,
So the answer to 320, does the buyer, Frank, take free of the security interest held by RFC?
I put Frank loses.
Frank loses, why?
9201A, generally a security agreement is effective according to its terms between, I could read the whole thing.
No, that's fine. The security agreement is effective as against purchasers, but more importantly, 9315A1.
Okay. And
9315A says the security interest continues notwithstanding the disposition of the collateral. Questions? 9315A. The security interest continues notwithstanding the disposition of the collateral, right? That's the default rule.
Okay.
Unless you can find an exception, the default rule is the security interest stays and the buyer takes subject to it. So Frank loses, right? So 9315A1. Now, part B, would we get a different result if the bank's interests were unperfected? So we started off by saying they were perfected by filing. That's what the problem said. Which, by the way, if you're answering a question on an exam and I say they perfected by filing, What don't you need to tell me? How to perfect by filing. Because I just told you it was perfected by filing. Sorry, I say this over and over again. I always get people who answer the question going, well, the way you perfect by filing for this filed perfected security interest, don't care, no points. At least I'm not like Markuson. Markuson takes points off. I don't do that, right? He does, right? He takes points off. I don't. I don't think an exam is a natural occurrence in the lives of people, so I'm not as concerned about people. You hurt yourself by talking about stuff that's not relevant. I'm satisfied with that being enough of a penalty. Okay. What if it's unperfected? Is there another way for the buyer to beat the secured party? I'm not saying Markuson is wrong. Okay? For his class, that is correct. I don't do it. That's all. Is there another way to beat the secured party?
Yeah, Frank has priority,
Under what section?
317B,
Okay, and what does Frank have to prove in order to win under 317B?
that he gave value and he received delivery of the goods, and that he did not know of the security interest, and it was unprotected.
Yes. So the BFP purchaser, bona fide purchaser for value, you heard this in real estate law, right? BFP, you know that term? If you don't know that term, learn that term. BFP, right? Bona fide purchaser for value beats the unperfected secured party. 9317 was subsection?
B,
Okay, so it's not over if there's a security interest if you're a buyer. You just got to hope that they're unperfected. Great. Part C. Would we get a different result if the bank knew and approved of the sale? What is this referring to? Just part of the problem.
Oh, the exception to where the one from the lecture where it's like the first exception you talk about, and the secured party kind of like lets them take free.
Absolutely right. And what section of the statute is with the language that we're looking at?
I didn't write that down.
Well, you have the right law, so that's correct. 9315A, right? Unless the secured party agrees to sell or to release the security interest, it stays. But the secured party can agree. So, you're Frank. Bill wants to sell you his equipment. What are you worried about? Right? You're buying from someone who doesn't sell ice cream making machines. So what should Frank ask? Frank's the buyer. What should Frank ask? First question is there a security interest, right? Okay, yes. What's the next thing Frank should do? Call RFC, right? Or tell Bill, I'll buy this, but you got to arrange for a release. That's easy. It's very straightforward, and this happens all the time. Obviously, it happens with very high-valued things like equipment. That's where you're going to see this kind of negotiation. But there's nothing secret about it, right? Just ask the secured party. And what if you're an RFC and you get a question by your debtor who says, I'd like to sell some of my equipment, what are you going to say to that person? You're the bank now. What would you do?
I'd say that's fine, but we want to do it for closing, we want money.
You pay us. Yeah, fine, great. The bank would have no problem with that because they would be paid off, at least partially, right? So they would just get the loan paid down. So that's how this, in a normal transaction where a company is selling equipment that is subject to a security interest, the bank would be involved and the bank would demand that payment be paid to them, or at least in part, right? So that the loan value gets reduced. Now, I can't tell you that won't also freak out because you're lending to an ice cream selling company and the ice cream selling company is selling the equipment that makes the ice cream. You might go, are you guys shutting down? And then you might go, yeah, we're taking all of it, right? Maybe, that might happen. It might make you nervous as a bank. But if you're not nervous and you're happy with this, you just say sure and you write a letter and it says, I hereby release the security interest. I approve the sale free of the security interest. Yes?
What part of the statute is the agreement?
There's no part of the statute, oh, sorry, go ask your question, I jumped in too early.
The agreement where you can work with the bank?
There's no part of the statute that sets out the language of the agreement except for 315. So 315A says if the bank agrees, essentially. And how they agree is a different question. I think we have a problem later on dealing with the cattle, I think, where you can make other arguments. But for this purposes, we're just saying written agreement is the best. Good? All right. What's the default rule with the sale of collateral subject to a security interest?
You,
Continues.
It continues. Default rule. Always start there and look for an exception. All right. Paul Pop was a rock singer to whom ONB loaned $8,000 so he could buy stereo equipment for his road show. Paul purchased the equipment, and on April 10th, ONB filed its financing statement in the proper place. So he bought on April 2nd, and they filed on April 10th. What kind of collateral is this? Most likely. Why? Great, I think that's right. Why is it equipment?
Because he needed to put on the show and that is his job.
So it's not consumer goods. Is it farm goods? No. Is it inventory? No, because it would be inventory if it were like paper. It was used up quickly. But this is equipment that's going to last a long time. Okay, so it's equipment. Is it a purchase money security interest? Is the original security interest a purchase money security interest? Okay, it's not consumer goods, so it can't be automatically perfected, but it could still be a purchase money security interest. Money is needed to buy the collateral, the company lends the money for collateral that is purchased by the buyer, and the money is actually used to finance the purchase. Okay, great. So it's a purchase money security interest. When did they file? 8 days afterwards, right? So that date is telling us what? In the back of our minds, we're going, oh, we got that 20-day thing, right? Okay. However, ONB filed its financing statement in the proper place. However, in the interim, on April 8th, Paul sold the equipment to used Stereo Heaven, who bought it with no knowledge of the bank's purchase money security interest. Does ONB or used Stereo Heaven have superior claim? At the time that the stereo equipment is sold to the used store, is there a filed financing statement on the equipment? So, no filed financing statement, not consumer goods. Are you perfected or unperfected? Unperfected, right? Does a buyer who has no knowledge of a security interest beat an unperfected secured party? Yes.
yep.
That's all I'm asking. I haven't done anything else, right? Does a buyer from an unperfected secured party win? Yes. So if the seller never files the financing statement and they always remain unperfected, the buyer beats them, right? What's the difference here?
They have the 20 days to file.
And what section of the statute are we looking at?
317E.
9317E. So 9317B says the buyer beats the unperfected secured party unless 9317E. And what do you have to do to win under 9317E to get the retroactive filing? After? Okay. Everybody good with that? So what this is pointing out is that there is a possibility of a sale before the purchase money secured party files the financing statement. But it doesn't matter as long as they file within the 20 days. It reverts back. So here we have, it's not Andy Audio, right? Who are the parties? Who originally bought the Paul Pop, right? Is that right?
Yeah.
He's the original buyer. Who does Paul Pop sell to?
Use stereo.
So use stereo something or, yeah.
Heaven.
Use stereo heaven, so USH, right? But they have a security interest with it, who? Is ONB a purchase, is this a purchase money security interest?
Yes.
Okay. This, right, the security interest is created on April when? When do they grant the security interest?
Second.
And when do they file?
10th.
And when does the sale occur?
The 8th.
Right? Okay. On the 8th, is ONB perfected? No, they're not. They're not perfected on the 8th. But they file within 20 days. Sorry, this was the 10th, right?
Mm-hmm.
When they file. What happens? It relates back their priority, the 20-day, and they get this, the purchase money secured party super priority. 9.317.8. You all good with that? Cool. I think the key is to chart it out, right? So, and I should have done it this way. 4.2, 4.8, 4.10, right? And what we have here is a date that starts running, and it goes until 4/22. And if there's any filing within that period, then you have the advantage of the 9.317E super priority as a purchase money lender. Okay? Problem 90. What's the problem with problem 90? What kind of collateral are we talking about? Sorry? Farm products, right? And in 9.320A, what's the exception to the buyer in the ordinary course rule? What's the exception?
Other than for exploitation farming operations.
Buyers of farm products do not get the benefit of the buyer in the ordinary course protection. Why would that be? Just from a policy perspective, why would you exclude farm products?
Because they're gonna get changed immediately into something else, or used. It's hard to get the, like if you're buying corn or something, it's gonna be hard to get that corn back. It's not what you're looking for.
No. I see what you're saying. Not a bad way to analyze it. It's actually simpler than that. We like farmers more than we like other people. Article 9 has a number of provisions that help out farmers. And how do you help out farmers? By making it easier for farmers to get loans. How do you make it easier for farmers to get loans? For the lenders to have protection against buyers. Okay? The farmer is in the business of selling farm products, right? So buyer in the ordinary course would exist. What's the problem for the farmer? If their bank does not have super priority, the drafters of the code thought, the farmers won't be able to get financing. So this protects the farmers because it lets it be easier for them to get financing. That's just the way it is, right? That's the Article 9 answer. Okay. There's a federal law answer which protects buyers of farm products. And that's the stuff that I didn't ask you to prepare. So don't worry, farmers do end up getting treated the same as other sellers of products. It's just that federal law had to kick in. And that's what the subsequent case and problem dealt with. But I'm not asking you to know that. Okay. But there are places in the code where farmers beat out typical, and creditors of farmers in particular, beat out other kinds of creditors. Okay. We skipped problem 91 and went to problem 92, right? So we have Mr. and Mrs. Halyard, who bought a boat with money borrowed from the boilerplate National Bank, which took a security therein and promptly filed a financing statement in the proper place. Once again, they filed, it says they filed properly in the proper place, and they took a security interest. No analysis needed about whether or not they're perfected. They are perfected. Halyards sold the boat to Oil Slick Boat Sales. Used boat concern telling Oil Slick that the bank's interest in the necessity of the monthly payments to the bank. Oil Slick turned around and resold the boat to Mr. and Mrs. Blake. Okay. So the original buyers are Halyards, right? And they got financing from ONB. And then they sell to, what's the name of the boat place? Oil Slick. Is Oil Slick a buyer in the ordinary course? Are they buyers in the ordinary course? No, why not? So, was it consumer goods?
Was.
Yeah, probably. I think it sounds like it's consumer goods. Is Oil Slick a consumer buyer? So the garage sale exception doesn't work. Is Oil Slick a buyer in the ordinary course? Why not? The Halyards are not in the business of selling. Is ONB a perfected secured party? Yes, it says it. It says they're perfected. Okay. Right now, alarm bells should be going off. Uh-oh. Security interest continues, right? Who does Oil Slick sell to? The Blinks, right? Is Oil Slick in the business of selling boats? Is this a sale that might qualify as a buyer in the ordinary course? Yes. Right? This looks like a buyer in the ordinary course. Does it apply to this sale? In other words, does the buyer in the ordinary course rules of 320A cut off ONB's perfected security interest?
Yes.
Ah, yes. And I'm sorry, the answer is no, but thank you for playing. What's the problem? Take a look at 320A. Whose security interest does it cut off? The buyer in the ordinary course rule cuts off which person's security interest? The buyer's sellers. So of the two, Halyards or Oil Slick, which security interests does it cut off? The buyer in the ordinary course rule cuts off whose security interest?
I don't know.
Any security interest created by Oil Slick, the seller, right? Did Oil Slick create ONB's security interest? No, the Halyards did.
Right.
Do the Blinks take subject to ONB's perfected security interest? Yes.
Okay.
So, you shop on eBay. There are a lot of people who sell used goods on eBay, right? But it's not necessarily, right? They're not the people who originally purchased it. Somebody else, they bought it from somebody else, right? They're a reseller of used goods. Is it possible that the seller on eBay buys goods subject to an existing security interest? And it's not, the seller on eBay is not a buyer in the ordinary course because they're buying from individuals who have stuff that is consumer goods. They're not in the business of selling stuff. So, right? Oil Slick bought from somebody that is not a seller of boats. Therefore, Oil Slick is not a buyer in the ordinary course of the Halyards business. Therefore, this security interest continues. And it was perfected so 9317B doesn't work. And O&B didn't say, yeah, go ahead, we don't want our security interest anymore. So 9315A, security interest continues notwithstanding the disposition of the goods. Oil Slick sells to the Blinks. Is Oil Slick in the business of selling boats? Yes. Are these consumer buyers? Yes. Actually, it doesn't even matter for consumer buyers, right? Are they buying from somebody who's in the business of selling boats? Yes. Did Oil Slick create the security interest? Everybody. Did Oil Slick create the
No.
security interest?
No.
No! Not a buyer in the ordinary course. Not a 320A situation, because Oil Slick did not create the security interest. The Halyards did. And so the O&B security interest continues notwithstanding the sale. All right, I want to take a minute here as you sink in this crappy situation.
So to avoid something like that? if it's an
Don't
ex-
buy from used sellers.
No, I guess that's true. But like,
That's the only way to absolutely protect yourself.
so can you, I mean, I know you can do title searches on cars and stuff, but like, can you do something similar to that on?
Excellent question. What should the Blinks ask before they buy the boat?
There's a security, but how can they check for themselves? Like,
So, what's the question they should be asking Oil Slick?
Who'd you buy from?
And what are you gonna do when you have that information?
Go talk to
Ask
them.
who they, if there's a security interest.
Well, you don't even have to ask them. What do you do?
Look it up.
Search. Yeah. The only way to protect yourself against their security interest is to search under their name. Right? Because if there's a filed financing statement filed by O&B, right, they filed. How's it gonna be indexed? Under their name. Blink should ask Oil Slick, who did you buy it from? And then search the UCC records, once they know where the Halyards live, for this existing security interest. That's the only way you can protect yourself when you buy used goods against a security interest created by your seller's seller. And I can't repeat that. That sounded really good, and then, right? Oil Slick seller, the Halyards, created a security interest, but because Oil Slick is not a buyer in the ordinary course, and O&B was perfected, the Halyards, the security interest created by the Halyards in favor of O&B continues in the boat, and it flows through from Oil Slick down to the Blinks. And the Blinks take subject to the security interest. So when the Halyards don't pay, and Oil Slick doesn't pay, then the Blinks lose the boat. I think the technical term for this is, that's poopy.
So are the Blinks not buyers in the ordinary course because Oil Slick was never a buyer in the ordinary course?
No, Oil Slick is in the business of selling boats.
Yes.
The Blinks are buying from somebody selling in the business of selling boats. But the security interest at issue is not one created by the seller. So therefore, they don't get the buyer in the ordinary course protection against this security interest, right? This security interest was created by them, not Oil Slick. And that's just that's the straight on language of 320A. You take free of your buyers of security interests created by your seller, the buyer's seller. Yes.
If there had been an assignment of the security agreement
To somebody else?
to Oil Slick, like, and all that was on paper, would that have worked?
Oh, so Oil Slick becomes the assignee of O&B's security interest? Yeah, then it would be one that they have, right? I think that would work, yes. Yeah, that never happens. I can't think of a case where that has happened and the analysis was done. But I think the issue is, O&B is no longer the secured party, Oil Slick is. Yeah,
You mentioned eBay,
yeah,
which seems like a virtual garage sale.
yes.
Now,
But no, so understand, who is the seller on eBay?
it's,
If it is the person who purchased the product, so if it's the original buyer, then you have a garage sale exception. But if you're buying from a company,
right, unless they're companies. So where does a person?
Would you rather buy from a merchant or from the original owner? Like 100,000 sales or 4? Would you rather buy from the merchant because you think you're going to get the goods and they're going to be okay? But that does not protect you against this. If you buy from merchants who have bought from other people, and those other people are consumers who created security interests, sorry, you take subject to that security interest.
Okay.
Yeah.
So
Like I said, the technical term is that's poopy. No, you can't write that on the exam. Well, you can. You can write whatever you want. But. Another question? Yeah.
Please. So how many sales does an individual have to make before they're considered like a business?
Very good question. Don't know. I think 1 would be okay if they're holding themselves out as a merchant. Right? As soon as they say, I'm in the business of selling stuff, then they're a merchant. And then it could be a buyer in the ordinary course. Yeah. Now, the question is, they purchased as a consumer and now they're selling as a seller. Well, what does 320 require? Does it require that it's non-consumer goods? No. It only requires that you buy goods from a seller of those goods, essentially out of inventory, at the time of the sale. You then take free of that security interest. I think that's fine. It doesn't say a security interest created by someone who is a merchant. It just says created by that party. No, I think that's fine. eBay, there's a lot of risks associated with eBay. This just happens to be one of them. Do I think that this is actually a practically big problem? No, I don't. Because most of the stuff on eBay is sold that's used is low value. And nobody's going to spend the time and the money to collect it. The only company that I'm familiar with that actually took this stuff seriously was Sears. Right? Does Sears even exist anymore?
Yeah, they do. I know where one is.
You know where one is, right? Yeah, they used to be they used to be the Amazon of the 70s and 80s, right? Sears, 100% always foreclosed on all stuff subject to their security interests. They were nasty. They went after people. There are many cases, particularly in California, of them violating the consumer protection laws because of their collection practices. They were ruthless. Most every other merchant was like, it's not worth the effort. Okay, that's buyers. I will probably test on this, right? Buyers are cool, man. You can sort of slot them in a lot of ways.
The term buyer seller is confusing to me. Can you tell me which one of those is the buyer?
Well, let me ask you, who do you think is the buyer seller?
Hayards? Halyards?
Yes. So Oil Slick is buying from the Halyards, and they are the sellers to Oil Slick. They created the security interest. However, they are not merchants. They do not sell boats. So therefore, Oil Slick cannot be a buyer in the ordinary course of Halyards business, because Halyards are not a business. They're just consumers. Just like it's like the ice cream truck situation. Yes, they're merchants. They sell stuff. But what they don't sell is equipment. They sell ice cream. So again, buyer in the ordinary course does not apply. The prototypical example is you go to Walmart and you buy a TV. And I don't care who you are. You could be a company buying a TV to put in your office. It's going to be equipment to you. It does not have to be consumer goods. All it has to be is that you go into Walmart and you buy it in the ordinary course of Walmart's business. I don't care who you are. You get the buyer in the ordinary course protection. That's not a consumer situation. It has nothing to do with that. It's, does the seller operate a business where they sell this stuff out of inventory? Okay. Let's talk about the stuff that I wanted you to quickly go through for today. So we're starting on 243 with statutory lien holders. The key to statutory lien holders is 9333. And it's essentially security interests that are created by possession through statute or law, right, or common law. It's the mechanics lien situation. So 9333 says if a mechanics lien comes into existence because the mechanic has possession of the collateral, then they beat out other perfected secured parties. We like repairmen, essentially, right? We like people who do work for you and extend credit to allow you to buy their services, okay? So let's just quickly go through the problems just so we understand what's going on here. Which creditor has superior interest in the car under 9333? The answer to that is RFC would win here because what are the rules of 9333? In order for the mechanic to get advantage of the priority of a mechanic's lien, they have to have possession. As soon as they give up possession, they lose that special priority. So the mechanic's lien, the statutory lien, only has priority under 9333 while the mechanic, I'm just going to say mechanic, but it's anybody with a statutory lien. It could be obviously a car repair shop, but also sometimes dry cleaners have this. People who do work on your home, things like that. They only have the advantage of 9333 while they have possession. So that's the key. The statutory lien beats out the prior perfected secured party only while the mechanic has possession. So that's why RFC wins in problem A. Problem B, what if the car had been in Mike's possession when the conflict arose? Would it matter under 9333 that the finance company never gave the consent to the repairs? No. Read the statute. There's no notice requirement. 9333 just says you have a security interest that exists under law and you have possession. There's no, there's no knowledge issue whatsoever. It's irrelevant. Read the statute. The statute does not have a notice requirement. So the mechanic's lien would win regardless of what the secured party does. Doesn't matter. Okay, now, who here has ever done any work involved with a transaction, either their own or somebody else's, where you had to sign an affidavit regarding repairs? Anybody ever see this? In my business, when I was doing real estate work, I worked at a finance company. We often had people sign affidavits saying they hadn't had work done in the previous 60 days or 90 days. That was for this reason, so that we wouldn't be surprised that there was somebody out there with a statutory lien on the property. All right, that was real estate, but it was the same problem. Problem C. Once Mike's released the car to Hattie, did its lien reattach whenever she returned to the garage? There's nothing in 9333 that says it can't reattach. So I think the best answer is it reattaches. Whenever the mechanic gets possession, the mechanic's lien has priority. And again, it can be a dry cleaner. It could be anybody who has a special lien that comes into existence by statute because they've provided services and extended credit. I will not test on that, but I want you to know it because it could come up. Statutory liens have special protection under 9333, and the key issue is, do they have possession? Okay? Fixtures. Okay. I want to point you out to a comment to 9334. Comment 3 to 9334, second paragraph. Go there, read the second paragraph of comment 3 right now. Take a second to look at it. On 334, comment 3, second paragraph. Okay? When we're talking about fixtures, we got to keep a couple of things in mind. The first thing I want to talk about is, what is a fixture? So it's defined in Article 9, in 9102, right? So we go back to 9102, and we see that under paragraph 41, subparagraph 41, fixtures means goods that have become so related to the particular real property that an interest in them arises under real property law. And then we see in 9501 that you can file something called a fixture filing under 9501A. And that's particularly 9501, A1. So what does this mean? Okay. Goods, and it's only goods. Goods can be fixtures. But not all goods can be fixtures, and some goods evaporate as goods when we are talking about real estate. If the competition is between two lenders who are not real estate lenders, two Article 9 secured parties, we don't care about this. It's an Article 9 competition. Sometimes a mortgage company can have a security interest in the personal property that's on the property. That's the competition we're talking about, between an Article 9 secured party and a mortgagee. So if it's between one Article 9 secured party and another Article 9 secured party, where do you file to perfect? Secretary of State's office. Okay? So that comment is essentially saying there are three kinds of goods that we are talking about when it comes to collateral. Stuff that is not fixtures, stuff that is either a fixture or a good, and stuff that doesn't exist. So let's start with the stuff that does not exist. The building materials in the building, I think I mentioned this quickly in one of my lectures. The building materials evaporate. They don't exist. They are part of the real estate. There's no fixture issue whatsoever. They do not exist. They become part of the real estate. They're not separable. They're part of the building. So the wood that the contractor buys to frame out the house, the wallboard that the contractor buys and puts on the wall, part of the house. Not goods at all, period. Okay? The furnace that the contractor buys and installs in the house is goods, because it is possible to sever it from the building, right? It's not part of the building the way the 2x4s are. Okay. The stereo, let's make this easier. Let's talk in language that you guys know. What would you guys buy for your house? TV, right? We all buy TVs, right? The TV that you don't attach to the wall, that's just sitting on a table in the middle of your sad little house. Why would I do that? That's terrible. Your wonderfully appointed, really elegant home is just goods. It's not a fixture. If you bolt it to the wall, maybe it's a fixture. But assuming it's just sitting on a table in your living room, it's not a fixture. Mostly. But let's just say it is, right? Stuff that you can just pick up and walk out with is goods. It's not part of the real estate. So you have to know two things with fixtures. Is it a fixture? And is the competition between an Article 9 secured party and a mortgagee? And it's only if the latter happens that we really care about the fixture filing. We don't care about fixture filings if it's two Article 9 secured parties fighting with each other, because they're not filed there. Article 9501 says you can file with the Secretary of State's office, and that's sufficient in a battle under 9322A. And again, if we go to 334, which is the priority battle, I think, is it 334? No, 950. I'm sorry, I was going to refer you right to the section that talks about 9332. I'll find it later. Okay, so that's all we're talking about. So let's just quickly do the problems and see if we can understand how that works. All right, so we have problem 99, and the answer to problem 99 is it totally depends, right? The furnace that heats the building and water, fixture, right? That feels like pretty much a fixture, but not building material, so it is a separate good, so we could have a priority battle as between the mortgagee and the Article 9. Pipes. They carry hot water through the walls. Closer call. Maybe part of the building and doesn't exist, but could maybe be removed. I don't know. I think it's the former. I think it's part of the building. Couch that's been sitting in the living room for 20 years.
Good.
Feels like goods, right? Okay, for our class, it's goods. I am not telling you there are no crazy cases that it is the case that there are occasionally cases that say stuff like that is fixtures. Weird, it seems to me, because that you can just pick up and walk out with. Okay? Lavish designer bathtub, the case cited says fixture, right? But not part of the house, because it could be removed. It was special, but they call it a fixture. And then security cameras. Tracks, wiring and equipment for wireless internet access. Fixture or not fixture? Case says no, it's nothing. It's just goods. Sorry, not that it's nothing. It's goods. It's not a fixture. Because you can just rip it out and walk away with it and nothing will happen to the building. The cases are weird on this. It's just not very good, right? So, the 2x4s in the building disappear. The refrigerator, the water heater, fixture. If you have a battle with a mortgage company, you got to go to 334. If it's a TV that can walk out the door, Article 9, don't care about fixtures. Okay? And that's what these cases say. I think the counts is not a fixture. But question 5 here, there's actually a case that says the security cameras, because they're easily removed, not a fixture. Okay. Why is that important? The real estate law or the mortgage itself might grant the mortgage holder a security interest in personal property that become fixtures. Okay. Now, how do you protect yourself against the mortgagee that could have a security interest in fixtures? You file a fixture filing. Where do you file it? Anybody?
Secretary of State.
No, that's a regular filing. Where do you file a fixture filing?
Like the county office.
Wherever you file a real estate filing, and that's almost always the county filing office. Okay? There's a whole bunch of priority rules in 9334. I'm not going to test on them, but I want you to know about it because it is possible it could come up on the bar. So we see in problem, let's see, 101, because I think I skipped 100. I'm not doing transmitting utilities at all, and I don't think the bar would test on that either. The question here is, Simon Mustache decided to erect an apartment building on a vacant lot he owns, so he borrowed $4 million. All right, he's a construction borrower, right? And so Construction State Bank is a construction lender. It turns out that there are special protections for construction lenders. And here we have Simon and CESB signing a mortgage, and the question is the mortgage effective as a financing statement? It can be, right, under 9502C. During the construction of the apartment building, Simon bought a furnace, giving Blast a security interest. Where should Blast file its financing statement? Well, it can file it with the Secretary of State's office. That's fine, but it can also do a fixture filing under 501A. A1. Great. Who wins? The construction bank. 334. D, right? Is it D? Sorry. H. Mortgage is a construction mortgage to the extent that it secures an obligation incurred for construction of an improvement on land. Everything installed in the house during the construction that is financed by the construction company, well, even if it's not financed by the construction company, the bank's security interest in fixtures, because it's a construction loan, beats everybody else. That's what H says. And that makes sense, right? We want to encourage the building industry, so we allow the building industry financing companies, the banks, to get priority in that stuff. Okay. Right? The code prefers the perfected construction mortgagee over all others since it financed the construction of the building of the house. That's what 334H tells us. Okay. There is an exception under E for priority of security interest in fixtures over real estate property. And if you look under E, 2, before the goods become fixtures, the security interest is perfected by any method permitted by this article, and the fixtures are readily removable. So then, factory and office machines, equipment that is not primarily used for lease or replacement of domestic appliances and consumer goods. 9334 E2C protects refrigerator sellers and washer and dryer sellers and furnace sellers. If you're in the business of doing replacement stuff for consumer goods, that's where you get protected. So if you're Walmart and you sell somebody a refrigerator that you're replacing in their house, 9334 E2C says you don't have to worry because it's consumer goods, you're automatically perfected, right? It says perfected on any method, and it's a replacement. And that's really all I think you need to know about it. I think you need to know that construction mortgage companies have super priority over everybody, but sellers of replacement consumer goods that become fixtures get priority under 9334 E2C. But you have to be perfected before it becomes a fixture, but that's easy if it's a consumer good because the minute it attaches, it perfects. No filing necessary. With respect to the tax lien stuff, I think the key issue here is 2 things. The IRS gets super priority over everybody. The government always wins. And if you haven't learned that by now, in your last year of law school, that being the government's like the best thing, okay, well that's a lesson you ought to take away from it. The IRS always wins. Their liens jump ahead of everybody else. There is a little bit of an exception for advances made without knowledge of the existence of the tax lien. And there's a 45-day rule, but that's under the IRS rules, and I'm not testing on IRS stuff. But be aware of it. Tax liens jump to the front with only certain exceptions. And that's when you lend money without knowledge of the existence of the tax lien, right? Until when they haven't yet filed. As soon as they file that notice of lien, they beat everybody. Doesn't matter. Okay, Bob Woodward is here today. I'm having lunch with him, not me personally, like the whole faculty. But I'm gonna go, I'm not sticking around afterwards, I'm gonna leave in 1 minute. But I wanted to tell you, he's also meeting with students this afternoon. If you don't know who Bob Woodward is, who doesn't know who Bob Woodward is? Bob Woodward worked for the Washington Post. He and Carl Bernstein wrote the articles in the Washington Post that got Nixon to leave office in 1973. He did the investigative reporting that discovered that Nixon knew about the break-in in the Watergate Hotel. And he's been writing articles about authority figures ever since then. He wrote a book about the Supreme Court at one point. I think it's called The Brethren, I think is the name of it. I think that's right. He's a very, very well-known reporter. He's been reporting on power, people in power for 2 generations now. That's why he's here. I think it would be interesting to ask, meet him and ask questions. You have the opportunity. That's why I'm here. Have a really good rest of the week and a good weekend. See you next week. We start some really fun and exciting stuff called bankruptcy, which will make